Welcome to your key discovery point. I am Brett Burney from Nextpoint, joined by Doug Austin of eDiscovery today. Doug, you got a treat for some folks that may want a little bit more coverage on hyperlinked files or modern attachments, depending on what corner of the camp that you want to come from. Well, if you are interested in getting even more coverage of this topic, which I don't mean to make light of, it is very important. Well, we've got yet another little well, this is, in this case, it's a stipulation, but I like it in the way that you've put it. It's a little bit, maybe some potential guidance for people that are dealing with this from the UberTex litigation. This is officially UberTex passenger sexual assault litigation out of the Northern District of California. And you posted a few days ago about a compromise that both sides agreed to, which I thought was an interesting tactic here.
Indeed. So obviously, you and I talked about the previous ruling in this case, which I think happened just like 8 days before the ruling I covered here. And in many of the disputes, Judge Cisneros, California Magistrate Judge Lisa Cisneros, ordered the parties to meet and confer.
Right.
And that was the ruling where they dealt with some of the other kind of issues over and above producing from Gmail, hyperlink files in Gmail from Google Drive and what have you, and dealing with things like emails further down in the thread. You have to produce hyperlink files for those and what have you. So she ordered the parties to meet and confer, and 8 days later, she filed the order adopting stipulation regarding production of hyperlink materials that the parties agreed to. And I basically, because it was short, just put the entire thing in there,
Right.
which of course makes an easy blog post too. But one of the things that's notable here is that the parties agreed that plaintiffs can make one request per week of up to 10 hyperlinked documents that have not otherwise been produced, and the defendants need to produce those within 5 business days to the
Wow.
extent possible. And if they can't, then they're supposed to meet and confer and what have you. But I found it was interesting because it's a bit of a compromise. Judge Cisneros has really kind of worked through the issues with the parties on this case, which I
Right.
think she's done a great job of. I just had the EDRM March case law webinar
Yes.
with Mary Mack, Tom O'Connor, and Judge Andrew Peck. And Judge Peck made an observation that it's interesting that the stipulation essentially is kind of the same approach that Judge Parker had the parties take in Nichols v. Noom, which is the
Oh.
kind of the very first case that most people are familiar with from the modern
Right.
attachments dispute. So it's kind of interesting that it's come full circle, but it does seem to be, perhaps at least for now, kind of that compromise that can enable parties to request documents that they know they've got to have, the most important ones. And if they're requesting 10 documents, hyperlinked documents per week, then of course they're going to want to make sure they're requesting the most important ones they've identified and to keep that process going. So I think it's interesting that they came to this agreement, and I have a feeling we'll see more agreements like this in cases
Yes.
where they can't figure out an approach, but at least can figure out how to produce some of the documents while the technology continues to develop.
Yeah, I just thought that that was interesting in the fact because again, we've talked about this, and in fact, I'll let people know about a webinar we did a few months ago, where if you want to get a little bit more background on this, but in the sense that it's a little bit easier to grab the emails from, in this case, it would be Gmail or Google Suite for Business, but the same thing could be said probably from Microsoft 365. We grab those emails, and then there are links in there, right, to documents that are being stored in Google Drive or in Microsoft in OneDrive, for example. We can get the emails. We can't always automatically grab those linked files, those hyperlinked files. But in this case, this could be maybe an easy way that the parties can come together, that as you're going through those, reviewing those emails you've collected, and you come across something that that you find, okay, this email would be important and maybe this document would also be important, then that's where you can come and provide a request. And that's what I was alluding to earlier. Like, this could be a little bit of direction on how to deal with this, at least in sort of the infancy of, while we're waiting for technology to maybe catch up a little bit to this. And that's what I just took away from this, that it was pretty interesting that, I mean, they've only got a few days, right? It's like every week, every Wednesday, you gotta give 10 requests, and they got 5 business days to come back to that. And there were some, allowances in here that it seems like after that, the defendants have the ability to review the document, of course, or privilege or any other protections on there, before they actually produce that. So I feel like there's a little bit of fail-safe that are in there. One thing real quick, Doug, that I found interesting, just because we've talked about this quite a bit, is that nowhere in here did I find that Judge Cisneros or the parties were even talking about what version of that document necessarily that they would have to collect in there. And I don't know if that was maybe in some other agreements that we don't have access to, but I just found that interesting, because after all of these years and these months that this case has been around, it seemed like maybe that would have come up, or maybe the parties are just like, you know what, we'll just take whatever version that you can get access to. Maybe, I don't know.
Well, yeah, that's a great point because, in the previous rulings, Judge Cisneros has made a point of talking about the contemporaneous version of the files.
Right.
So,
Exactly.
that's the thing, is that here it's not really specified as much. Obviously, I guess, and we won't have the opportunity to be the fly on the wall. It could be that the plaintiffs could be requesting the documents in such a way that they'll be asking for the contemporaneous versions of those documents. But the way they put the
True.
stipulation in place didn't necessarily force or require that. So who knows if they pushed for that and the defendants rejected that idea, or if they just kind of said, hey, we'll just put plain language and then you can request any version or contemporaneous version. We don't know, but it is interesting to see that, as the case has been worked and the issues have been worked, the Judge Cisneros and the parties were able to come together and say, here's how we're going to do it, at least for now,
Right.
for these issues.
If you want a little bit more background, maybe on some of the earlier decisions in Uber Techs, in this case, that we've been following for quite a while, Doug and I, along with Kelly Twigger, several months ago, I want to say it was last fall, we did a webinar called Modern Attachments or Old-Fashioned Hyperlinks. A little bit of a funny approach on the title there, but we do go through a lot of the logistics here, and even some of those cases. Kelly obviously does such a great job. In fact, you always are great to link to Kelly Twigger's eDiscovery assistant. So if you do want to read the entirety of this very, very short stipulation here, then you could, or this order here, you could do that. But at least it's great to kind of see that even in context of the other cases on there as well. But I'll make sure we include a link to that webinar in the show notes if it's something that you want to dig into a little bit. But today, your key discovery point, sometimes looking at maybe a little bit of a compromise and agreement between the parties is not such a bad deal. Doug, as always, thanks for joining us, and we'll talk to you next time.
All right. Thanks, Brett. Thanks, everybody. Bye.